House of Assembly in the amendments made by the Honourable the Senate to the Companies Amendment Number 2 Bill 2019.
You continue, Bill.
Mr. Speaker, I also beg to give notice of the Returnable Containers Amendment Bill 2019.
Private members' notices, notices of questions, reports from select committees, first readings of bills. First reading, same bill.
Mr. Speaker, I beg to give notice of the returnable. The returnable containers. The first reading of the Returnable Containers Amendment Bill 2019.
The question is that the aforementioned bill be read the first time. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Statements, congratulatory and obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42 subsection 5, 43 and 44 be suspended for the remainder of today's sitting.
Second, please.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended.
Government business, sir.
Government business is now the order of the day.
Order number 12, sir. In the name of the Honorable Minister of International Business and Industry, to move the passing of a resolution to seek the concurrence of the Honorable the House of Assembly in the amendments made by the Honorable the Senate to the Companies Amendment Number 2 Bill 2019.
Honorable Member for St. Michael North.
Thank you, Mr. Speaker. Just briefly to say that the reason the amendment made by the Senate was necessitated by an accidental deletion of a portion of the legislation that really did not require amendment. And the Senate accordingly made the adjustment in the Honorable Chamber, and I beg to move, Mr. Speaker, that this Honorable Chamber concur in the amendment made by the Honorable Senate to Section 170, subsection 2A. That's correct. The correct section. I have it in front of me.
The concurring amendment.
Mr. Speaker, back to move that this time Madam Chairman concurring the amendment made by the Senate to this bill.
One second. The question is that this Honorable Chamber concur with the amendment proposed by the Honorable Senate. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Number 6, sir. In the name of the Honorable Attorney General and Minister of Legal Affairs, to move the second reading of the Family Law Miscellaneous Provisions Bill 2019.
Honorable Member for St. Joseph.
Mr. Speaker, there are not many occasions in this chamber where I could faithfully and honestly promise that I would not detain the chamber long. I think Henry VIII is famous for saying to his wives, sorry? I think Henry VIII is famous for saying to his wives, I won't keep you long. I therefore am perhaps fortunate enough to be able to say to this chamber that I won't keep you long on the matter of the amendment to this bill. Mr. Speaker, it happens from time to time that as government deals with its issues and as administrative agency deals with issues that you come across some hiccups. Many of them are innocuous. But some of them, sir, are very, very far-reaching, and therefore we are here today to correct a major challenge in the family law legislation of Barbados, sir. Now, Mr. Speaker, there are, I believe there should be 2 bills.
Yes, dear. Order 6 and 7.
And I would therefore want, sir, to have a cognate debate in relation to both of them. And I seek the House's permission so to do. Nigel?
The question is that Order 6 and Order 7 be debated as a cognate debate. All those honorable members in favor, please say aye. Those against, please say no. Meeting the ayes have it.
Yes, sir. Thank you, sir, for that accommodation. Now, to give the Chamber a brief history, the process of a divorce in Barbados normally requires, well, it always requires a 2-step process. The documents are filed and you appear before the judge, and the first part of the divorce would be an order under Section 27 of the Family Law Act called a decree nisi. When once arrangements relating to property and custody of children are sorted out to the satisfaction of the court, you can then get a decree absolute. There are times, though, when you have what is called an uncontested divorce, and that really happens when there's that happens when there is no property to be divvied up between the 2 parties, and also, and perhaps more importantly, when there are no children of the age where you have to deal with maintenance issues. The old practice would be that you would go before the judge and the divorce would be granted on one sitting. Mr. Speaker, under our old rules, it was possible when we created the post of master for the master of the court under the old regime to do uncontested divorces. But then we brought new rules into play, and those new rules did not so permit. But a very convenient practice having commenced, it just continued unabated. And therefore, parties would go before the master in an uncontested divorce and seek the necessary orders under Section 27 and under Section 42. Problem is, sir, that the master had no jurisdiction to make those orders under the new rules. And therefore, Mr. Speaker, parties would have been divorced by order of the master of the Supreme Court at a time when the master of the Supreme Court did not have the lawful authority to do so. Now, sir, when I say that some of the mishaps in governance are often innocuous while others are far-reaching, you would immediately see, sir, that this one is so far-reaching that an individual who was divorced in a situation where the master exercised the discretion that he or she did not have, that divorce is void ab initio. And sir, if the divorce is void ab initio, then it means that you are still married. problem is, of course, that there are individuals who, acting in good faith on the strength of order from the master saying that you are now divorced, they would have gone on and remarried. But, sir, we all know that if you are not divorced, by engaging in a second marriage to another party, you are now committing a grievous criminal offense called bigamy. I regret to say, sir, that if we do not pass this law today, and it is difficult, sir, to even try to begin to find out the numbers of people who are potentially affected by this. But any of them who will have gone on to get married, sir, in a situation where their divorce is itself, there's no point blaming anybody, I think, but it falls to us, sir, to put it right. Mr. Speaker, what we are here to do today, therefore, is firstly, master during that particular period, then we declare in law that that divorce is valid. And that therefore, that act, therefore prevents you from being subject to the criminal penalty. But, sir, it is a very complex. An individual might have gone on, remarried, had a new family, that might cause him. Inez from Checker Hall may also have gone on to herself remarry to somebody else and entered into. Let me assure the opposition that I don't actually know an Inez from Checker Hall. Those individuals, sir, would have acted innocently. But things that they would have held as being appropriate arrangements through no fault of their own are in fact unlawful. So the first thing that we're doing, sir, is to validate the divorces that were ordered and preserving arrangements that would have entered into by individuals afterward. It is a big issue, but a simple fix. And I don't think there should be anybody in this chamber, none of us, I imagine, are affected by it, but there should be no one in this chamber who should have any reservation at all about it. But, sir, through error, a good practice developed. And that practice has some value even when we change the law, because it is everybody knows that the legal system in Barbados the judicial system is overburdened by cases, and it really became convenient for individuals to get divorces pushed through the system in this way. So the question which arose to the executive, the government, was a simple one. Something was being done that was an error, but notwithstanding that, is there something salutary about it that we should preserve? And the legal profession certainly holds the view that rather than throwing out the arrangement lock, stock, and barrel, that we should still try to preserve the power of the master to grant divorces in certain circumstances. Now, the point is, sir, when you go before the master in a situation where there are no children, there's no property, Mr. Speaker, the master has judicial authority to do many things under our rules of the Supreme Court. But the master has no jurisdiction to do anything under the family law rules. So I'm not going to bore the chamber with the mechanics of it, but the point is that we still feel that there is some value in permitting the master to carry out those duties and help through that mechanism to take some pressure off of the court system. Now, sir, that is no small matter. Time and time again, and for many years, this chamber would have heard me go on and on ad nauseum about the challenges to the delivery of justice. They would have heard me repeat that well-known aphorism, justice delayed is justice denied. They would have recognized that we've worked assiduously to carry out some of our manifesto commitments so as to see that dreadful logjam that exists every day at White Park Road wrestle to its knees. Now, sir, having cases decided swiftly will not just depend on bringing on additional judges. And I think, sir, that that is an important element that needs to be stressed. You can bring on more judges, and we have done so. But unless we put other arrangements in place to be able to help the judges themselves do their work in a more efficient and effective way, then we really will not have made the kind of strides that we need to in order to wrestle the problem to the ground. So, sir, by diverting or permitting the diversion of parts of a divorce application to the master, it now allows an additional set of judicial individuals to help to make decisions and move things through the courts. Now, sir, we've just, having brought on additional judges, we've just tried to concretize the arrangement where we will have two of our High Court judges working exclusively in the Family Law Division. Now, Mr. Speaker, let me say that the one thing that we have to recognize about government is just about every decision that you make requires a transitional period. Divorce proceedings will have been started in some instances years ago, heard before judges, and need to be completed. So you could not say as of X date, 2 judges are doing only family without recognizing that there will be matters that are still pending that need to be resolved. So those matters that are already in train still have to be completed by those judges. In addition to that, sir, we still have to work our way through the administrative arrangements, and those things are all being put in place. But the point is that as at today, we still have to do some more work in terms of crystallizing a family court where those judges are the only judges who will hear family matters. We're not there yet, in part because there are legacy matters that are still being heard by other judges who will not be in the family court. But this is an important initiative, Mr. Speaker. It is important because in every endeavor, when individuals specialize, it creates opportunities for efficiency. Mr. Speaker, you are an attorney of great renown and experience, and I'm sure that immediately you will think to yourself, you know, I hope I can get Judge so-and-so to do this particular case. It isn't that Judge so-and-so's judicial mind or leaning is any different to anybody else. But the fact is that for some reason you may be able to identify that particular judge as having a facility in doing a particular kind of matter. And it may be a simple thing. It may be that they have a greater interest in it. It may be that they did postgraduate work in it. There are some judges who you would want to hear a criminal matter, perhaps because they spent many years at the criminal bar. And if you cite a case, he immediately understands, or she immediately understands what it means and what are the ramifications of it, as opposed to an individual who has never set foot in the criminal court, who is now encountering this thing for the first time, and you now got to spend the next 2 days trying to explain.
Only 2 days, honorary member?
Well, you may now have to spend an extraordinary period of time trying to explain why this thing is happening. It is no different, sir, in family. For much the same reason that some litigants prefer to go to particular lawyers for family cases because they know they do it every day. So they develop a facility and expertise with it that another lawyer who might not see too many of them would find to be something to struggle over. So there's great desirability, sir, and this is not new, this is not novel. All across the world, judges specialize. And this endeavor on our part is to try to ensure that our family law judges specialize and therefore can bring the benefit of a more intense and a wider experience to the deliberation of cases. And sir, that should, in a real way, help them to make decisions faster because of their familiarity. But you might ask, well, if that's the case, then why are you preserving the power of the master to do particular orders in relation to divorces? Well, sir, the particular orders that the master will be doing will be the orders under Section 27. I said at the outset, sir, that in a divorce proceeding, you have two stages. You have the first stage, which is the decree nisi. At that point in time, the court just says, okay, based on the information presented to me, I'm going to grant your divorce. But I will not make it final until you deal with the other matters. Now, at that point, sir, there's no investigation into who did what. In fact, we long ago got rid of that situation. In the old days, sir, you had to show cause why you should get divorced. You had to be able to blame somebody, and so you had to prove all kinds of sordid details. We got rid of all that stuff, and we now have no fault divorce. It's nothing to do with fault. All that you're required to prove is that the marriage has broken down irretrievably. So in the first stage of a divorce, sir, all that has to happen is that the parties have filed their documents, they depose, in general terms, the circumstances in which the marriage is broken down, and unless there's a dispute, the order under Section 27 will be made. So, in fact, sir, while it is a judicial process, it's almost administrative, because at that point, parties aren't proving anything. They don't have to dispute. We break up, break down, whatever it is, the marriage is now at an end as far as we're concerned. So there's no inconsistency, sir, between having specialized family courts and permitting the master to exercise this very preliminary power. All the master has to be satisfied is that the people were married, that they're subject to the jurisdiction of the court, and that the marriage has broken down irretrievably. When once those three things are met, that first part of the divorce is done. Now, the fact is, sir, having two family law judges doing all of the divorces in Barbados is itself a challenge. It is itself a challenge, sir, because we have a large number of divorce applications and family law applications, because divorce is not the only thing that judges deal with. But we have a lot of applications that are heard, that would be heard by a family court. But at that point, sir, when you only have two judges, the pipeline becomes very narrow. The pipeline becomes very narrow. And it is therefore a prudent thing to allow the marshal, sorry, to allow the master, to allow the master to take some of this pressure off of the court, sir. Now, our manifesto commitment in relation to the family court is wider and broader than this. Currently, in fact, I believe I can say that we've just completed a significant study into the establishment of a dedicated family court, and we had a very eminent individual from Trinidad who herself served as a master in Trinidad and who specializes now as a consultant in making recommendations about matters such as these. And she's just completed her work. And that is to inform how we will further build out the family court. You see, sir, as I said, under its current setup, we will have two dedicated family court judges. But we have to go much further than that. We have recognized that there are a lot of issues that are attendant with family disputes, especially as they relate to custody and care and control of children, that are informed not necessarily by issues relating to the children themselves, but by issues and conflicts existing between the parties. And so one party will get vexed with the other party and say, you ain't carrying my children away around that new woman that you got. And you got a whole other issue that has now erupted from that kind of arrangement. And therefore we recognize that there's a lot more that has to come as we build out a family court system other than just installing judges. And so what will this new family court arrangement look like? It isn't final yet, sir. But we do know, and we've already begun the detailed discussion to see what the staffing will be like. We need social workers. We need social workers, sir. Well, we need quality and trained social workers to help to intervene and manage some of the day-to-day issues that trouble some of the dysfunctional families that find themselves before the court in custody battles and maintenance battles and so on. Mr. Speaker, if it were as simple as saying, you want $400 and he offering $2, let me split in the middle and his train, everybody will go away, we wouldn't have a problem. But it doesn't work like that, sir. Because what happens is, often a man who is aggrieved at having to pay maintenance, or a man who is aggrieved at having to pay so much maintenance, he may just get whatless and don't pay it. Because he knows that by the time you get back to the court, 6 months would have passed. 6 months would have passed. So this is his way of spiting you, the mother. So those are the kinds of things that are happening. Now, is it appropriate for a judge to deal with that all the time? No, sir. Because what a judge has the power to do is to sanction you if you don't comply with the court order. Now, we've all heard about the instances where people get sent up for contempt of court because they didn't pay maintenance or didn't do this or didn't do that. But we also recognize that while it is sometimes appropriate to punish an individual for contempt of court, it does not generally get to the root of the problem. So, sir, we've long recognized that hand in hand with the judicial process, we need the intervention of trained people like sociologists. We also need to have psychologists available to the court. Again, there's often a lot of overlay, other issues that are affecting the ability to properly resolve the dispute between the courts to properly resolve disputes between the parties by the court. The fact is, sir, our judges are not psychologists, they're not sociologists, they're called on to make rulings based on the law and based on their best judgment. Well, let me explain to you what happens, sir. If a judge has to ask the question, is this particular environment the best one to raise this child? You know what a judge does now, sir? The judge asks for a report, but you know who he asks for it? He will ask somebody, sir, from the welfare department to do a report to determine or to help him determine whether the conditions in which this parent is raising the child are adequate. Now, sir, no disrespect intended to any of our public servants, but that is an immediate mismatch. A welfare officer, whatever his training, a welfare officer works in the welfare department. And his day-to-day job is a different kind. But all that the court can do is say, I want a report from the welfare officer. Well, it could be worse, sir, because they could ask for it from the probation department, which has a criminal bent and would be even more of a conundrum. So we have a situation where unless the parties themselves are able to pay for the expert advice of a psychologist, the poor people have to rely on reports from welfare department and so on. And sometimes, sir, because the welfare officer is busy, how many welfare officers we got? I don't know. I don't know how many there are. But because 12 welfare officers. 12 welfare officers. And so when a court regularly now has to write and ask the welfare officer, I want you to do a report on the household of so and so. They can't drop everything that they're doing, and it fits in their hierarchy of duties, because their day-to-day duty is to work in the welfare department. So it gets tacked on as they have time, and so 6 months later, you're still waiting on a report. No, the poor judge has to do the best he or she can, but often again, because the kinds of orders that you have to make are sometimes black and white, pay this maintenance, this is the custody arrangement, it presents a problem because there are other issues that have to be taken into account. And therefore, we acknowledge and intend to provide when our family court is completely built out, we intend to provide those additional services so that on the spot, families can get the care that they need. The problem is, sir, that, you know, and I'm not an expert in these things, but I've heard somebody talk about dysfunctional families as being an organism that is ill. And it caused me to do a double take. I said, well, how do you mean? How a family could be sick? How a family could be ill? But when you think about it, in many ways, when a family is not functioning properly, it's very much like if the human body is not functioning properly. If you have a broken leg, then you can't go to work. If you have a damaged element of a family, sir, then, you know, the family can't function as it should, especially in a situation where that family is now severing ties from one parent to the next. Now, sir, the one thing that we can be sure of is that this society must do whatever it can to protect its children. And when you have dysfunctional families and the court can't put them back together again like Humpty Dumpty, often the casualties are the children. Now, sir, I don't have any empirical data, and therefore I will not attempt to draw any conclusions. But I will say that it would not surprise a person to discover that sometimes children in our schools who are difficult to discipline or who are not paying attention in the classroom are often manifesting challenges from a home that needs help. And as I said, sir, judges are not healers. Judicial officers make decisions, and they make decisions based on the evidence that's given. It is not a judge's job to try to make a party feel good about the order that he's making. And in fact, sometimes judges have to be downright clinical and take the emotionalism out of all of these things. So when a judge makes an order saying, this is the maintenance arrangement, I don't care how you find the money, but pay. This is the custody arrangement, and don't breach it either. Those are black and white things. But, you know, how people live isn't well reflected in black and white. How we conduct ourselves, how we relate to each other, sir, that is black, white, gray, all kinds of shades in between. And we feel that a properly functioning family court will be different to the kind of family court that we had in the past. And it will be a court that will be able to help to heal while the judge makes the orders that are needed. It isn't novel. It is working quite well in Trinidad. It's working quite well in other parts of the Caribbean. But we recognize that unless we bring people to a place where they are comfortable in accepting the decisions of a court, the risk of them breaching those orders or the risk of them reacting negatively to those orders is going to be greater. Now, one of the things that we've committed to in our manifesto, Mr. Speaker, is not just dealing with the High Court arrangements, but also dealing with the Magistrates' Court arrangements. And I have to say that it is, unfortunately, we don't have the ability to transform everything at the same time, because how we function and how we build out these institutions are in large measure based on the availability of resources. So, for example, right now we have one master of the Supreme Court, and I have petitioned the Prime Minister, and she is prepared, subject to finances, to give us a second master so that we are able to deal with that kind of case management thing at a faster rate. But these are all High Court arrangements. What about the dysfunctional families that have to deal with the Magistrates' Court every day? I can give the public our assurance that as we deal with the High Court family arrangements, the Magistrates' Court arrangements are going to be changed as well. We are currently looking, Mr. Speaker, at a Child Justice Act. It should be in Parliament very soon. But we recognize that there are a lot of... If I told you we have an act in Barbados called the Prevention of Cruelty to Children Act, sir. I don't think a lot of, it sounds funny, doesn't it? Because everybody know about the RSPCA and the Prevention of Cruelty to Animals. But they'll be a little bit surprised when you hear that we have an act called the Prevention of Cruelty Act. So the Prevention of Cruelty Act, as far as I recollect, was enacted probably in the 1920s. In the 1920s. And it is that act, I believe, that still has the offenses of wandering and so on, where a child found wandering on the street can be picked up by the police and sent up Dodds. We have a lot of arrangements in our law, and I'm very happy, sir, that we've been able to establish the Law Review Commission, but the commission is about 50 years of work of a commission in order to bring all of our laws up to date. But this is a perfect opportunity now, sir, for us to look at how we deal with a whole set of other family arrangements as they come into contact with and sometimes come into conflict with the law, and bring them into a more understanding, a more accommodating 21st century. So our courts, our magistrates' courts, still have to deal with family issues in a way that is not appropriate for modern Barbados. And it has to change. And we've given our commitment to change it. And while we perhaps don't want to get into that side of the debate, I want to reiterate, sir, that we have committed that as we build out our new family court, that we will fully accommodate the magisterial jurisdiction. So here is what presents itself, sir. In the magistrate's court, the magistrate will normally only hear maintenance matters. And the payment processes are awkward. They're not modern. So that a mother has to go to the court and try to collect maintenance for a child here. She has no way of knowing if the man paid the money or not. So she will routinely take time off from whatever she's doing and go to the court and often be told the money ain't here. But she's wasted the whole morning. Taken the morning off of a job, sir, that she's probably earning minimum wage at and can ill afford to take time off of. Now, Mr. Speaker, it isn't rocket science to be able to do these things. You could probably go on your cell phone now and know if there's money in your bank account. I have a phone, sir, but I don't bother because the account empty. But these are common arrangements today. Now, why does it elude us to think that a single parent living in Horse Hill, living in the Garden Land or someplace else, should not be able to check her phone in the comfort of her home or when she gets a break from work and see, yes, there's money there. This is so common. It is such a common sense thing that you wonder why we weren't doing it all along. Now, just imagine if she's it. Now, if there's no money there, then of course we have to deal with the problem because money is supposed to be there. But at the very least, sir, we've taken one difficult exercise off of our backs. And that in itself will help to make arrangements easier. Now, sir, in addition to that, if you're able to identify that there's no money there, you can sooner take steps to deal with the content issue than if you have to go up at a court and stand up for 3 hours waiting for a court clerk to get around to talking to you to see if there's money there. So we need, sir, there are companies in Barbados that no longer give their employees a check. They don't give their employees an envelope with money in it. The money is deposited to the bank account. And they go with the ATM. Now, that's the kind of initiative that the Ministry of Finance is currently examining to see how we can better facilitate the payment of maintenance to mothers. In Trinidad, the payments are digitized. And you will get your, the man pays in the money, and the system pays out the money to you automatically. So money comes in, it's credited, and it's available to you in your bank account. And we want to bring that kind of initiative. And the Ministry of Finance has been having that discussion now with our commercial banks, because obviously banks don't do anything for free, and you have to come to a method of dealing with it so as to minimize the cost, because we are intent that the parent who has to collect the money should not have to suffer from paying any fees if it can be avoided. So we're going to change that system, sir. Now, there has been some talk about centralizing the magistrate's court in terms of its family division, and there may be some attractiveness to that, but I think that we recognize the importance of magistrates being in communities, and one of the advantages of magistrates being in communities is the simple fact that by being and working in a particular district, they get to know some of the people, and that can often help them in making decisions. While if you try to bring all of the maintenance matters in the magistrate's court into Bridgetown to be dealt with in a central way, you will now have an impossible situation. In fact, we would have made what is already a difficult situation worse. Mr. Speaker, there's much more to come. I am satisfied with the strides that we've made as a government in relation to dealing with some of these things over the last 18 months. There are some people who I suspect don't want to give any credit to the Barbados Labour Party for achieving anything. I read an interesting editorial. I think everybody read it. And the person is saying that essentially that we've done nothing for the last 18 months. Now, I'm not going to get into a spat with anybody. Whoever the editor is entitled to write and say what he wants. But I believe, sir, that in the last 18 months, this administration has climbed some tall, tall mountains. We've climbed some tall, tall mountains. We've restructured debt. We've saved the US dollar. Sorry, we've saved the peg of the US dollar. We can't save the US dollar. That's somebody's job. But I think you know what I mean. We've saved the fixed rate of exchange between the Barbados dollar and the US dollar. And we are continuing to fight all kinds of other issues every single day. The Minister of Industry and International Business last year had to wrestle our country out of the perils of a blacklist by the EU and OECD. And that fight continues today. We're working on doing a similar thing in relation to the FATF. We've been rebuilding Barbados' name and Barbados' profile, not just in the region, but also internationally. And yes, it is taking a little long for the buses to get here, but they are coming. Yes, it is taking long for the garbage trucks to come here, but they have started to come too. People who once reflected that the treasury was empty, not a penny there was to spend, sir. But somehow or another, this administration is able to come in and work miracles by waving Harry Potter's much fabled wand. Sir, the miracles that we've been working have been miracles in the hands and pockets of Barbadians on a day-to-day basis. Increasing pensions, changing the regime in relation to taxes, putting dollars back in Barbadians' pockets. Now, sir, in relation to the courts, that has been part of our mission. We have completely transformed the way in which judges are appointed in Barbados, and that, sir, is a major achievement. And what has it yielded? Sure, there will be disappointments, but we now have a system of appointment of judges that we can look anybody in the world and say it is fair and it is transparent. And that is just part of the process. Going now towards specialized courts, that is also part of the process. And so, sir, I am pleased that we are in a place today, not just to fix things that the last administration knew about for 10 years and should have fixed, but that we are also able, out of the fixing of those things, to recognize that there are some viable elements that we should retain and allow the master to help our judges to move matrimonial matters through our system faster. Over the next 6 months, sir, I'll be able to report to this chamber further initiatives and progress on further initiatives in relation to the overall delivery of justice. It is like trying to push a car to get it started. When you start to push, it moves slowly. I've had to push an old car already. I had one. I had to push it regular. But no matter how many people you have helping you to push, the first few inches forward slowly, but then it gathers momentum. And the judicial system, I believe, in Barbados is at the point, sir, where it is gathering momentum. And I think that the new judges represent a breath of fresh air, and the specialization of these new judges demonstrates to the bar and to litigants that we're serious about a speedy dispatch of cases, and that we are serious about making judicial officers and the entire judicial system in Barbados more responsive to litigants. And the family law jurisdiction of our court is not going to be left out, sir. So, sir, these are two small amendments. Just to reiterate, we are validating all of those divorces that would have been granted without lawful authority. So nobody has to worry now. Well, when it passes through this house and the other place, nobody will have to worry about whether they're divorced. Should I call my lawyer? Who it was that do my divorce? I got a check back. I can get locked up because I gone and married Inez from Checker Hall, and on and on and on. So we're taking that burden off of people's shoulders, but we're also saying, in addition to validating, we are preserving a similar power to the master in relation only to the first stage of divorces. And I think, sir, that is a salutary initiative, and I therefore crave the support and indulgence of this chamber as I ask that this bill be read a second time.
Thank you very much, Mr. Chairman.
Mr. Speaker.
Mr. Speaker, sorry. I beg your pardon, sir. Mr. Speaker, I'm still in yesterday's mode, perhaps. I don't know Inez from Indian Ground. I don't know Inez from Indian Ground, so I'm not going to get into her business. I do know Sister James from just over the road, but I'm not going to get in her business either. And I'm not really going to get into the matter of who is legitimately divorced or who is not. I think the Attorney General and the government is trying to set that anomaly right. But it gives us the opportunity to focus a little bit, and that I intend to do, on the matter of family as a primary institution in our socio-human development in Barbados. In fact, in the totality of our development, family is critical, it's basic and foundational unit. And family is under threat in Barbados, and I want to suggest that. It is a position perhaps which is arguably put, but it is my view that family in Barbados is under threat. There are those dynamics internal to family life with which we're very familiar that constitute in part the source of such threat. But a lot of what threatens family life in Barbados is to be located as a source in the economic experience that we've gone through in the past several years, and which we're still passing through. A lot of it, I imagine, is to be attributed to the socio-cultural context of life in these days, with all of what we're exposed to as a people. But then there's also a dynamic which I consider to be quite sinister, and that is the values deconstruction agenda of the alternative lifestyle movement. And we have to be acutely aware of this as a nation if we are to preserve family as an institution and family life as we have always desired it so to be, as not only a primary and foundational unit for all that we become, but that context in which our nation's children are birthed and raised, and in which they grow up to be citizens of this country. Against that backdrop, I just want to offer a few points for consideration, and perhaps most of what I should say is addressed to the minister with responsibility for child matters in Barbados as well as family matters. We have to ask ourselves the question as to what is happening with children in the broken relationships of which we speak. I do not know if any formal study has been done as to the impact upon our children when they are made to face the trauma of broken relationships, especially those which reach the court and have to be settled by judicial process, and which result in separation, of course, and ultimately divorce, the breaking up of families. What befalls our children in that context? A lot of the time, I believe, we seek to offer solutions to problems without understanding the essence of those problems. We look to formulate solutions without putting in the necessary effort into unraveling the causes of the problems in the first place. We end up dealing with symptoms of the disease, symptoms of the ailment rather than the ailment itself. And therefore, problems persist, and chronic ailment in family life is perpetuated across the country in too many instances. And it mars it mars what Barbados is and can be at its best. To what extent are these children psychologically affected? That's a broad and general query, but more specifically, to what extent perhaps the stress and trauma of these experiences induce a disposition to deviance. We are now at a stage in Barbados where we are wrestling perhaps more than ever before with problems in our school population. These problems don't start, I imagine, in the school itself. The school is but a context that perhaps with all of today's dynamics allows for the further development of these problems, but I suspect they start at the level of the family, at the level of the home. And we really must formally study this to have a better understanding of it, that we might be best positioned, even in the context of limited resources, to respond to the problem. Family-induced disposition to deviance, dynamics at the family life, we need to look at that. We train people well to be engineers. I think we got one in here at least. We train people well to be lawyers, legal professionals. We have a lot of them in here. Some suggest too many. I don't agree with that, by the way, Mr. Speaker. We train people well to be lawyers and to be medical professionals, and we see them in the Parliament of Barbados as well, and IT specialists and carpenters and bus drivers and drivers of sanitation trucks where we can find them. We train people to do these things. We do not, in my view, put a sufficient and deliberate effort into training people in the role of parenting. I have always felt that there has to be in Barbados much more formal parental instruction. Mr. Speaker, you grew up in an age when grandmothers did that job well. You, seated in that chair, bedecked in all of your apparel, you seated in that chair, beset with and possessed of a sound mind and intellect, are the beneficiary of training that your parents probably would have derived at the feet of their parents. But that role of that grandmother, that role of influential persons in the extended family, has diminished significantly in Barbados. We have people today in multiple numbers who are parents before they stop being children, and they do not have recourse to their parental elders to help them. This society, in my view, suffers as a result of that, because we have children raising children. We have children who themselves did not benefit from proper parental upbringing, now being faced with the task of raising children themselves. The task of raising children, Mr. Speaker, is a very important part of the task of building a nation, building communities. And when a woman and a man, either independent of each other or together, are raising a child, they're helping with the process of nation building. They're helping with the production of with the molding of a mind, with the shaping of a mind, with the creation of a productive citizen. We cannot afford to spare any resource, in my view, in addressing that matter. I know that there are entities which are formally engaged in training and education of parents. We salute the work of Parados through the years, but the point I am making is that very deliberately we must see parent education as a critical undertaking and a responsibility of the entire nation through the organs of the state to facilitate that to a larger extent. Our children may best benefit from the best possible rearing that is available to them. This does not happen. Family life suffers, societies deteriorate, and it is ultimately the nation's loss. The government of the day, and I know this quite well, has committed to ensuring at the soonest possible time that no family in Barbados subsists beyond a basic and minimum economic level. In other words, that there must be a minimum level of income available to all households in Barbados. This is a very noble undertaking, perhaps difficult to pursue or even to achieve or even pursue in the current birth era, but it is an undertaking to which the government, I would implore, should stay seriously committed, and one upon which they should stay seriously focused. Because the stresses of family life are not at all divorced from the experiences of the households economically. And not to be able to support your family as a man is an emasculating thing. Not to be able to see to the support of your family as a woman must be heart-rending. For children not to be able to have the benefit fully of schooling, which is free in Barbados, because of other economic factors that prohibit that. Mr. Speaker, whatever they are, these are very serious things. And the commitment to ensure that there's a minimum level income below which families, households in Barbados should not fall is a significant commitment which I urge the government to strain every sinew, to use the familiar phrasing of the Honorable Attorney General, to ensure that that becomes a reality in soonest possible time. I would like to see the government mandate as well, Mr. Speaker, that investors, whether they be domestic or foreign, whatever the nature of the enterprise, especially those enterprises that have large complements of staff, I would like to see that government mandates that such entities build into their facilities a child care, a nursery facility. Government has done over the years, tremendous job in providing daycare facilities for parents who have to go to work every day. We have long ceased to be a Barbados in which a singular or single income in a household would suffice. You know that, Mr. Speaker, that even with your levels of earnings, one income does not do it. And I am trespassing, I suppose, into matters of which I do not have certain knowledge.
That is perfectly correct.
Thank you very much. And I think most Barbadians would say that one income cannot do it. So both parents are out on the job. And a lot of the times, therefore, we have to take into consideration what befalls these very children that are the subject of what I'm saying. And I think we have to mandate this. Companies look to government for concessions in various ways, and they get them in some instances. Companies benefit in various ways from state concessions of various types. And I think that we have to move to the place where the private sector, to a larger extent, helps the state to bear the burden of caring for the nation's children while parents are out to work. And I know that in the current economic stressful times, daycare centers as well are feeling the stress of being able to provide fully and comfortably so the service they would like to provide. And I know that this is an area of enterprise for private investors as well. But I'm saying those outside of people who directly invest in private daycare facilities. Beyond that, I believe the state must mandate some of these bigger enterprises to ensure that in their facilities, as big and grand as they are, wherever they're located, that they provide for daycare facilities for the children of their employees. I am happy with many of the things that the government is doing to address problems in the justice sector and to address the issue of wrestling the crime problem to the ground and dealing with the backlog of cases in the court and stuff like that. All of that and more has to be done because we're still losing the battle. And but I want to just refer to some comments which were attributed to Madam Justice Cornelius as chairman of the Family Law Council. She said the source of a lot of poverty, the source of a lot of dysfunction, source of a lot of alienation in society could be dealt with at the level of the family. And I believe that wholeheartedly. Further, she says, if we do not maintain this building block of the society, no amount of changes in legislation, increases in security, or financial support will help. And I've just taken this opportunity briefly this morning, Mr. Speaker, to suggest that with all that we do, we need to address issues relative to the family, which may be conducing towards deviance in Barbados, exposing our children to stresses with which they cannot deal, and impacting the positive, progressive development of our country, and constituting to some of the negative and undesirable features that we would do well to be rid of. Thank you.
Honourable member for Christchurch East.
Mr. Speaker, I wasn't intending to speak, but I do feel, especially following on what was said by the Honourable Attorney General, that I should say a few words. Mr. Speaker, why this particular amendment and the validation are so significant is people find themselves at a court or in a court, except for the very rare occasion where somebody goes to court to get married. Chances are, if you find yourself at a court, it is because it is a low point in your life, a traumatic experience. Whether you find yourself there in the criminal jurisdiction of the court, in the civil jurisdiction, or on a family matter, it means that there's some dispute, some issue that needs to be resolved and a judgment needs to be given. Family matters are perhaps the single most distressing reason to come before a court, because they involve the fracture of something that once held a lot of promise. Some have asked, why do we want to retain this jurisdiction within the magistrate to give the first part of the divorce orders to somebody? Why not just leave it to the judges? Are we not creating an additional layer that is incomplete in itself? I don't believe so. The Attorney General said it, and I fully agree, that we have a serious backlog in our system. And while the process by which the master would have granted divorces before has been pointed out to be erroneous, the fact is it created a great service. It helped with the flow of cases through the system. Cases that need not occupy considered judicial time but are more administrative in nature can be processed and dealt with and moved along, and leaving space for the more contentious matters to address a judicial officer, the appropriate judicial officer. There is no matter that people want dealt with faster than a matrimonial matter. Quite often it takes parties a very, very long time to get to the point where somebody files divorce proceedings or puts the matter before the court. So I have known a couple where the husband moved out from the house for 40 years. He'd moved out from his house for 40 years. He had somebody, the wife had somebody, and neither the two of them took it upon themselves to get divorced because there used to be a joke about it. Until such time as the husband decided that he actually wanted to get married. He was ill, and he wanted now to be married because he wanted no complications with the settlement of his property after his passing. So having done nothing for 40 years and living in a suspended state, he now wanted that divorce now, as fast as possible. Luckily, he was initially married to a good woman who facilitated him with that, because there's some other people who, knowing the full facts, would have stretched that one out to take advantage of the law. But the point is, we know that all of us who have practiced in the courts know that quite often it takes the parties, from the time the marriage breaks down, it takes the parties a long time to say it is over. You undergo counseling, you go before the court, sometimes you stall it out, sometimes you go back, you realize somebody is not really committed. But from the time one of the parties decides that, yes, this is it for me, then they want it done as quickly as possible. And I have always said that I believe in saving marriages. I don't believe in saving marriages at all costs. Sometimes it is better that parties go their separate ways. When the continuing angst in a relationship affects the parties, their reactions to each other, their interactions with other people, and also children. In this situation, or in the situation with children, then the court has to be more considered, because any orders that the court makes in relation to children has an impact on the children. It has an impact on how the parties deal with each other, because if one party believes that they're not getting their due in respect of the children, then they take it out on the other party and the child. It is a reality that we face. People use children as chips, as bargaining chips in divorce proceedings or in family proceedings. You haven't paid me maintenance, so you can't see this child. I don't like the way you spoke to me, so you can't see this child. How dare you bring that woman around my child? You can't see this child. And when I say woman, sir, under the Interpretation Act of Barbados, it's masculine, inclusive feminine. So we can switch these scenarios around. So anything that can be done to ease what is a necessary process in our law, I believe should be done. There are some, like me, who believe that eventually we may go a step further. We may give the master the full jurisdiction to deal with uncontested divorces, because there are some divorces, sir, where the parties know exactly what they want. Two people come to you, they've discussed it, and they say, look, we cannot live together, this is not working. He can take the children in vacation, I will have them for school, these are the arrangements, and I'm satisfied with how the maintenance is going. In those situations, sir, which I call amicable, granted that there are few and far between, but there are some. When you have a genuinely amicable situation, there is actually no reason it should even engage a judge at all. So while we give the master, the jurisdiction to deal with the Section 27 orders, there may come a time where we see the wisdom that the master should have the jurisdiction to deal with anything that's uncontested. If the parties see fit to come before the court and say, we have resolved our issues, especially if they come with a signed agreement, there's no good reason it shouldn't all be dealt with at one point in time. But let's take it in steps. Now, some people have asked, what's the difference between a Section 27 and a Section 42? Why is it necessary to split the divorce into two parts? So just for the purpose of explaining and allowing it to make sense to people who are listening to the debate and don't necessarily grasp why can the master do a piece but not the other piece. There's certain consequences, and I'm perhaps speaking as well to those who are thinking of getting married and who should do so with full information. I'm not looking at anybody here, but I guess there's some here who fall into this, so please heed my voice. You don't need a microphone to hear it. But yes, sir, there are certain consequences that flow from marriage. Under the law, a wife can sign for a husband. A husband can bind his wife. There are certain things that the law accepts for flow from marriage. The law has changed recently, but at one point in time, intercourse was a right in a union, so a husband could not rape his wife.
R versus riches, sir.
Correct, sir. This is saying what the law was, sir. Mercifully, we moved away from that point, but it takes you to the point where you understand that from the time you say I do, that is a sacrosanct union where the parties are supposed to be equal parties under the law, capable of binding each other. Now, our law recognizes one grounds for divorce. We are not concerned about adultery. We are not concerned about lying, thieving, cheating, stealing, nothing. The law is not looking into that. I mean, it's anecdotal evidence, sir, but at one point in time when adultery used to be a grounds for divorce, you'd have situations where they had these private investigators in Barbados who go hide in the bushes and trying to take pictures of people. And there was apparently a man, sir, who parked himself up by the airport with a camera in his lap and a newspaper, a Sunday Sun, on top of the camera trying to snap pictures of two people leaving the country together. But we got to the point of the ridiculous, the absurd, in order to establish the grounds of divorce. And the law, as it became more enlightened, said, you know, let us not start to point to flaws or force one party to embarrass the other. It is enough if you cannot get along and the marriage has broken down irretrievably. If somebody can establish before the court that the marriage has broken down irretrievably, that is sufficient. As far as the law is concerned, you do not need to be bound together any further. And what is the standard of that? The standard in Barbados is 1 year separation. So in the eyes of the law and of the court, if the parties have separated and do not live as husband and wife, you have to put a time frame on it at some point in time. If the parties have lived separately and apart, although even living in the same household, but you have not done your duties as a husband, she's not done her duties as a wife, you have lived your separate lives, although you share a roof, then the law says, after a year of being separated, we accept that that is of itself proof that the marriage is broken down irretrievably and you're entitled to get a divorce. Now, sir, until such time as the final order is made, the parties still remain married. We had issues where a party might file an action for the divorce, but one party is refusing to accept it. And until the order has been granted, that person is still seeking to exert their rights as a spouse, or as a husband or a wife under the law. So our law recognizes two aspects of divorce. The Section 27, which is the decree nisi, which is the first stage of the divorce. Effectively, have we established the grounds that the marriage is broken down irretrievably? If yes, then we can grant the first stage. Why that first stage is necessary is that effectively puts an end to the perception of the marriage. The husband can no longer bind the wife can no longer pledge the husband's credit, things like that. You can't take out the person's bank card and go and withdraw money and say, well, it's joint assets. No. So from the time you get the decree nisi, under the law, all of your rights in the marriage are now suspended pending the final order of the court. The final order of the court is simply meant to deal with the ancillary matters. It deals with the children, the arrangements for the children, it deals with any property settlement. And once the parties have settled their property, effectively you can sign off and say, we are clear as to where we are going from here, we are clear as to who has the children, who is responsible for the children, who pays what are the arrangements, the visitation arrangements, where the children are going to school. Once the court is satisfied that enough of the legitimate concerns have been addressed, that the parties can proceed with their separate lives without disadvantaging the children and without prolonging aspects in relation to property, then we can grant what is called the absolute. That's the final part of the divorce. For any time the absolute has been granted, the court washes its hands with that. You are no longer a concern of the court. Go in peace and live your lives. So the NISI is simply an assessment of facts. It really is a situation where the court makes a pronouncement as to the facts. It says, I am satisfied that the marriage has broken down irretrievably. If that is the case, then we give you the NISI. Proceed and sort out the rest of the stuff before the absolute. Otherwise, sir, if it was not possible to grant that at that stage, the parties would have to wait till all of the proceedings have been finished, which of itself causes more problems. Now, what people need to understand as well is if at the stage of the NISI, where one party says that the relationship has broken down irretrievably and we've been separated for 1 year, and the other party then contests and says, no, we got back together in August, we went on vacation in September, then that is not a matter for the master, that is a matter for a judge to deal with on a hearing where the facts are in dispute. So the position of the master in this is simply a matter of expedience to get past and tick off that box that we can then get to the resolution of the other facts. So I hope that I've served to clarify in some way why there is a split between the decree NISI and the decree absolute, and the role of the master in that. Sir, I applaud the fact that we've created a family law court. One of the most amazing things to me was to go to Trinidad and see their family law court. The family law court in Trinidad is separate and apart from the main court building. When you go into the family law court, there's a nursery for the children, there's a section for the older children. We have books, you have toys, you have things that the children can do. There's somebody to watch the children while the parties are in. It's very conciliatory. The whole feeling of it is one that suggests, while the law is a necessary part in here, it must not be oppressive. It is more of a mediation type structure than an antagonistic structure. And quite often, the ability to get to the end of a divorce proceeding depends on the cooperation attitude of the lawyers, and it also depends on the cooperation attitude of the judicial officers. If you have two acrimonious lawyers, then they can prolong and make a divorce miserable. And the more you prolong that process, is the greater damage you do to the applicants, the litigants involved in the process, and the damage that you do, the collateral damage that happens to the children who are also involved in the process. One good thing in our system is that the children are actually the focal point in the divorce proceedings. There's probably nothing more important than ensuring that the children are taken care of and the arrangements in respect to the children meet the approval of the court and often a welfare officer. But I wish to put out this call. It cannot be an easy thing to get divorced. I am married, sir. I hope never to be divorced. I mean, not one on that one. But it cannot be an easy thing. You put your entire business in front of the world, in front of people that you don't know, and ask somebody else that you don't know to pronounce on how you and the person that you once said, till death do us part, carry on for the rest of your life. It is not an easy process. There must be responsibility in the system. Everyone at every level, at every step of the process, must be aware of the heavy burden that is placed in matrimonial proceedings. There's a reason that matrimonial proceedings have their own act. There's a reason that family law proceedings have their own act and rules, that they don't necessarily fall under the general rules of the Supreme Court. Because they are, the very nature of it is that it will significantly affect the persons in a way that is not contemplated by the normal cut and dry aspects of the law. So I want to put this out. I had some frustrations, sir, as a lawyer with other attorneys. You have frustrations when you're married too. You have frustrations in relationships. I have frustrations with some of my cabinet colleagues. I once had a frustration with you. But that is well past, sir. That is well past. Nothing but love. But I used to have some frustrations. There's some lawyers who are very intent on winning. And you need to feel that you have won in a proceeding. Matrimonial matters are not the place for winning. It is not the place for competition. Because if somebody wins, it means that somebody else has lost. Our whole system, and I wish to reaffirm and beg that everyone involved in our judicial system, especially in relation to matrimonial proceedings, remembers that family is first. Even when you get divorced, that person is still your ex-wife. They still carry the title of wife. That person will be your family until the day one of you dies. If you have children, you are forever linked. So the process, while it is necessary, must be couched and engineered in such a way that is meant to just resolve an issue between parties to allow them to get on with their lives in the best way possible. One of these requires speed. Matrimonial proceedings need to be the ones that are quickest disposed of in the courts because they affect people every single day in all aspects of their life. And this amendment and this validation serve to allow us to continue to do that, which, although we have been doing it, has been found to be flawed. We are now seeking to correct it, to allow something that has proven to have some value to continue with the blessing of the law. I do believe that at some point in time, we're probably going to go a little bit further on it, but I will leave the rest of my speech until that time. So this was simply meant to inform my colleagues, inform anybody who might be listening. And I end by saying I entirely support the amendment and the validation that we're debating here today. Thank you, sir.
Honourable Member for St. Thomas.
Thank you, Mr. Speaker. I cannot speak to this bill in the amendments to these two family law bills with the eloquence of any attorney at law, but I shall speak to it as a person working within the system, particularly in the schools and in the community, and to lend my support to what the Honourable Attorney General presented here this morning. These challenges started, or let me say, since 2008, late 2008, August. These challenges will have been identified, and I am happy that today efforts are being made to place amendments on the statute books to arrest or to curtail some of these challenges. I know many who will hear my voice will want to know, what do I know about marriage? And I have never even contemplated being married because I know me and I know my personality and the nonsense that I see sometimes coming from both males and females in relationships, whether they be married or in families together, unmarried. It really causes a lot of concern for me. And so I congratulate those who have gone into that union, and the Honourable Member for Christchurch East who just spoke. I wish him many, many years of marital bliss because we know of the kind of challenges that will emanate from relationships and other women coming on board and other men coming at women and making all these gestures and offering all these wonderful things. And we're only human beings and we'll be vulnerable. But I support marriage life and I congratulate those who are married. But I also want to say that the amendment is timely because I believe that there are hundreds of persons who would have been given their divorce papers and might have found themselves in a bind as a result of knowing that they are still married. Many people want to move on after divorce. I've seen it so many times. I've got two sisters who have been divorced. Well, one fully divorced and the other one, the husband passed away fairly early and that might have been a good thing too. But the point is that they want to continue their lives and they want to get that release and that relief to be able to carry on and to start new unions or to do whatever they want to do. And it is unfortunate that sometimes when the separation comes, it has a lot to do with property. Property meaning a woman would have worked really hard with a male or vice versa, and they've got this property. And then when the outcome comes, because of a very good lawyer, and I know you're an outstanding lawyer, sir, and I highly commend you for your efforts. And I would not want you to be my lawyer, though, if we were married and I had to come to get my compensation or to get my benefits as a result of building a house with a partner or husband, and then I don't receive much. Somebody gives me $30,000 for a house that costs $300,000 I have to build. So sometimes you get those challenges, and they create another element of anger and bitterness among or between couples. And therefore, I know what divorce can bring. But it is interesting. I do know some couples who got divorced and got married again. And I will not call any name. I know someone who has only been deceased about 3 years now, got remarried to his wife after separating for a long time, or she got remarried to him, which is a good thing, because down the middle were the children. And those children suffered for years, as would be the case with any family. And I'm talking common law union. That was the expression I couldn't remember just now. And so that couple and those couples have gone back together, and they have lived happily according to what I recognize. The separation, sir, the divorce, creates so much dislocation and so much disorientation. And I'm focusing on the children now. The honorable member of the leader of the opposition spoke to it tangentially, and I believe that this should play an integral part for those couples who are contemplating getting divorced. I believe that they can find a way sometimes to make up. And usually you hear it is the woman, and the women get a lot of blame. And I don't expect you, sir, to respond to me because you're not in a position to do that. But I know thousands of people, and generally it is another partner who attracts the attention of the individual. And oftentimes it is a man who is stable, and a woman says, the friend at work, my husband gave me a diamond ring. My husband is sending me to France on a trip for my birthday and so on. And the friend in the workplace becomes jealous and eases up to the partner. I'm a woman, so I know. And I know about Jezebel, so I know. And therefore, it causes fractures in between there, especially when women have children. Because when we are young and trim, as I would have been 110 years, lots of fellows with haste and so on and so forth. But from the time you get that child as a female, the breast drop, your stomach remains large, all kinds of things, they get a little loose in the skin, and so partner wants you no more. Sometimes the men look like that too, but because they have a dollar bill, the women latch onto them, don't care how big the guts is. Women latch onto them, and therefore it causes that separation. And I was reading something in Christine in the newspaper this morning, and a woman who was talking and lamenting about a lot of things that happened in her life, a lot of women that were trying to come into the relationship, and she shared her experiences with others, and the others used that as a weapon against her, and she lost the husband who prepared for her so well over the years, despite his little running around with the other women. So I understand it very well, because I've been on this earth a very long time. And therefore, the children are the ones who take the cake with me. And I hurt having been in the classroom and see children who were so smart, so bright, suddenly became melancholy. And when you question them, Daddy and Mommy fought last night. Daddy and Mommy not agreeing. Daddy cursed Mommy this morning and tell her these starved children, and so on and so forth. It hurts little children. And I would want anybody who is contemplating getting married or going into any union at all, just remember the vulnerable children who suffer more than anybody else. But I must tell you, Mr. Speaker, sir, I know adults who, after reaching the age of 30 and 35 and their families separate, meaning mother and father, and the marriage is broken, they too are carrying the baggage. Why will my parents separate at this time? I love to be with my mommy and my daddy still, despite my age, and so on and so forth. So it has a lot of emotion, a lot of stressors that impact on those persons who are a part of those families. Children manifest these feelings in multiple ways. Some of them don't want to go to school, and even they go back home, and they don't want to even enter the house because daddy is not there, or mommy is not there. And therefore, the sadness envelops them, and they are not performing well in school. I'm going to get to the vulnerable families because the honorable member for the opposition made mention of it. But I'm talking in the regular families where most of them will be married with and a husband and a wife, and these children who were learning so well have started to lose interest, have started to drop in their performance, have started to remain very unruly, don't even want to go to school, don't want to hear anything anybody says, because in their thoughts, what has been happening at home and at night, or daddy being aware and can't see them because mommy say you're going with his woman, and the other member made mention of that. Or the other way around, I'm not letting you go in his woman's face or her man's face because I don't want you to be tarnished in any way or anybody taking advantage of you. And therefore, I think that as a country, we need to start looking more at forms of mediation where couples can come together in the early, and I commend those churches, and our member for, honor opposition leader and member for St. Michael West would be a part of that kind of, in that vanguard for counseling, not only after the marriage, but before the marriage. Many of them will say, we don't have sex before, but already the couple has sex, so. But move on then to help them learn about the principles for rearing children and living a good life and sharing and caring for one another and be the support system. And if we can get more churches and more organizations coming on board, I think it will mitigate the whole matter of separation in the way and the bitterness that comes with it. And I don't understand myself, how is it that when you meet someone, you love the dirt they walk on? You offer them the world. And then 5 years later, 2 years later, 20 years later, I have had enough of you, and you call the woman an old bike. Old bike because the body no longer has the shape and the contours and so it had before. Or if the man falls ill, diabetes kicks in, and then he cannot perform the sexual duties, he is called a no goods, or not able, or can't fulfill. So it goes in both ways, and I'm not going to be targeting any gender. And I say gender specifically and guardedly so because I know and I understand what is happening. Now, I believe that teachers need to have some special training. I was at Erdeston and I know the kind of training we had at that time. I can't speak to what is happening now, but I believe that teachers should be critically prepared to pick up the vibes when they see the changes in the children, and unless our ministries can have psychologists and so to be able to work with these children, because I know of the challenges the Ministry of Education has gone through, and therefore you don't just pick up and say abracadabra and get psychologists, but you would need psychologists and counselors and others who can work with these children, because if it can be dealt with in the early, it can be attended to in the early, I believe that it can ease the situation, but some children carry the anger for a whole lifetime. And if we want to really truly say we love our children, to both the males and the females, the husband or the wife, we have got to come together and make proper arrangements and take out some of the anger and the bitterness and the cursing and the insulting and so on, because it is impacting on that child who carries those scars for life. I also want Mr. Speaker, sir, to speak to what happens when it comes to child maintenance. I see it every day, so I know it. And I know of children whose parents, the mothers, put men in court because of lack of maintenance. And I saw those children crumble. And they became angry with their mothers because they felt, why would mommy put him in court? And unless we talk with children and take them through the various experiences and let them know what the changes are, I believe that dialogue in Barbados is critical, but a lot of people don't talk to their children. Just go ahead and quickly do it, and then the children suffer not understanding. If I don't get the maintenance, I am not working, or what I'm working for is insufficient. I cannot give you the full maintenance. Daddy said he's gone, he's not interested anymore. Therefore, we don't talk with them enough, and I believe that communication is critical in our culture. And we have lost a lot of it. Parents who do not talk out at the challenges to be able to let the children and the family understand what is going on. And so this child maintenance is a real set of madness and some fiascos that have me so concerned. And sometimes there are partners who have the money. And I'm not saying only the man should be given maintenance. I believe, sir, and you will guide us at in another forum as to how it can be done, where men who are working for a good salary, whose children are living with their fathers, will have to pay maintenance too. And if that is so, I shall be stand corrected, sir.
Honorable member,
Yes, sir. I beg your pardon, sir?
it speaks to equality, whether male or female.
Good, thank you, sir. And therefore, I see these children all broken, and you can tell children who were all well dressed and well prepared for school and so, and then when that separation comes, the children's clothing remains tacky, and they cannot buy the necessary school lunch, and they do not get the textbooks because there has been no money, because a father or mother says, I am not giving you anything, you're living with your father. No, little girl, let your father give you. Or little boy, you're living with your mother. Or I am not giving because I'm not even sure if the child is mine. That's the other problem that we hear. And I see videos, Barbadian men, I'm not talking about non-nationals now, or anybody from anywhere else. I see Barbadian men in videos who say, I am not giving the woman a cent, because she's going to get my money and give it to the new man she has. Or she's going to buy donkey hair and jewelry and clothing and gold teeth and all kinds of strange things, when the focus should be on giving the child. And I support men who say, I'm going to buy the groceries and help out because I'm not getting work in the way it used to before, and have a receipt though, because the court will require that. And I'm a novice, sir. I'm only a fireside lawyer, if you want to say that. But we had somebody here already who are no longer here. And I knew the law better than them. But that is another story. But the point I'm making is, I believe dialogue with these two persons, even though there's not a sexual relationship or a speaking relationship, to be in that family unit still has to happen if the children are not to be cut right down the center. And so, when cost of living is so high, and a man has to pay, or a woman has to pay $50 a week through a court, I know that it will match the wages or the salary the person gets. But $50 a week, what can it do for a child? It can't even pay a bus fare. It can't pay lunch money. It can't buy school clothes and books. It can't buy the pencil, the rubber, the new shoes, the socks, nothing. $50 is not saying anything in this time. And so I believe that too needs to be addressed in order for our young people to be able to maintain their children, whether it be a man or a woman who has the child in his or her custody. The cost of living is high, and I agree that although some of the females do foolishness, so do some of the men. Some would rather go and drink some liquor by the shop with the money, and then say, because I'm not going to give this to the woman because she want to go and spend the money on her man to go up to Farley Hill, and all kind of strange things, or she wants to do whatever is something stupid, that we have those children cut down there. And then what happens? They are in the classroom, they are in the families, they are in the neighborhoods wreaking havoc because nobody seems to care. And that is where my biggest concern is in relation to the children. Now, Mr. Speaker, I also want to refer to the welfare officers. The welfare officers are expected to be an integral part of this exercise. I believe the probation officers will too. Our welfare officers work really hard. I know there are many challenges. I know some of them perhaps could do better, but like any other profession, we have persons who do little or nothing, and they get the salary. And I'm not painting them black at all, because I can understand that they too have their own issues, and they too get divorced. They too have children who don't get maintenance. They don't get maintenance for whether male or female. But the point is, there are really hard-working persons, and our public is suffering because our numbers for welfare officers are so small. And when they have to undertake matters to do with the court and so on, it means a whole day away preparing records, or going down to the court and waiting for the case to be called when 25 people are up at Warren's Polyclinic, or somewhere in Silver Hill, or somewhere in St. Joseph and St. Andrew waiting. Sir, you are bowing your head as though you know it all already, because you've been there as a social worker.
I'm just listening, honorable member.
I beg your pardon, sir?
I'm just listening intently.
Yes, and I know that if I'm wrong, you're going to tell me stick to the facts. So I am going to try as far as possible not to defend them if there are things that are wrong and their communication with the public, but to say that I acknowledge the work they have to do. And yes, we do have social workers, the Human Strengthening Project. We have 26 social workers, and they're the ones who are working with the vulnerable families. We started up with 105 in the project, and the IC Bridge project that had 30 persons, 30 families, one per constituency, but that is now being merged into the Human Strengthening because that has already surpassed its period of existence. And we have identified 500 most vulnerable families, and a lot of those vulnerable families are single-parent families, but large numbers of children as well, and mothers who have children, and then their children have grandchildren, and sometimes there are 15 and 20 members of a family living in one dwelling where there are little or no proper facilities like running water and bathroom and so on, and it impacts on the entire family. But then when you get that one child, or those two children, these people are so vulnerable, sir, that another partner comes along and says, girl, you look real good, and I want to have a relationship. The relationship starts, and then you hear, but I want a child too. And then when that child is given birth, that man just vanishes. And more challenges in the family. So we've started to collect the information. We've got the 500 most vulnerable families already. We know there are many others, but I say most vulnerable because these are the ones who need proper housing, or proper shelter. These are the ones who need clothing. They need food, furniture, all the other basic amenities these families need, and it really is posing quite a lot of challenges for us. We were able to also identify the 500 most vulnerable persons, and I'm not going to speak now to divorce fully, but those other 500 persons are mostly senior citizens or persons who are disabled who require the extra assistance to be able to bring them up to scratch and to help them to be able to survive. And that's where the welfare officers and the National Assistance Board and those various entities come on board to make sure that measures are put in place for those persons to get the help. And that is why this financial year, I should say, I felt extremely proud that the Honorable Prime Minister in a budget speech extended that extra help to those families by putting in an additional $5 million to be able to meet the needs of those most vulnerable among us and to help them to at least get the basic needs fulfilled to be able to get to the next level. I know that training happens as well with those persons who are in the projects, and now that we have been able to have the same Human Strengthening project we profiled, we are now able to go to the next level in helping to organize matters associated with our most vulnerable. I want, as I come to closure, sir, to indicate that there are a lot of other institutions in Barbados beyond the churches and other groups that offer counseling, and I would like to recommend not only to the honorable members here, sir, but the rest of Barbados, that the bereavement services are available where communities can come together, whether it be community club, political organization, whatever, and identify having some bereavement services done. And I know that when we say bereavement, people think first of death. But bereavement is to do with loss. Any kind of loss. If I had to lose my husband, I would feel it. After all, it would have been my husband, that's why I married you. I would have felt the loss because I've lost a partner who would have been loving and daring and helpful to me and I to him, and vice versa when it comes to the males. So that is a loss. If I have to go for surgery, whether it be breast cancer, whether it be a man with prostate cancer or whatever, that is a loss of your income. It is a loss of your capacity to be able to serve your family, to bring in to be able to assist around the home and so on. That is a loss. If I lose my pet, that is a loss. And I'm not petering it down to simplistic things, but people who have dogs feel it sad when their dogs hang. My grandson cried a few weeks ago. I had tears in my eyes when my dog died. But I know it is a dog, and people say it doesn't have a soul, but I'm talking about loss generally. When we lose our properties, When we lose our home by eviction, that is a loss. And I'm saying this because every day in our country, sir, as we see happening in the rest of the world, persons lose something that is dear to them. To have your foot amputated, sir, that is a tremendous loss. And therefore, you need the counseling to do it. And there's so many other aspects of loss that I would like to recommend to communities to start a bereavement counseling unit so that it takes away some of the responsibilities from the welfare officers and others in the communities who are assigned through their training to be able to do it. And the training doesn't call for much. It could be one evening a week for 2 hours for like a 5-week or 6 weeks period, and that can prepare those individuals for being able to offer counseling services that will help to cushion some of what we don't see, and those underlying factors that impact on our children and our husbands and ex-husbands and ex-wives, and so they can be so tremendous. They can lead to heart failure, they can lead to aneurysm and so many different illnesses that I believe that as a country and as a people we need to get back to basics. In our villages, as children growing up, everybody in the village bore the burden of what would have been happening negatively in families. Now we've gone to this whole notion of the nuclear families, which is supported as well, but in our extended families, talking out the problems and taking guides from the adults and the senior persons in the community help our young people to stay away from the court. There are very few people in my mother's time who ever got a divorce. And of course, they tolerated too and bore the pains in their heart, like the Virgin Mary. They pondered them in their heart, but they could not have afforded it, but they tolerated it because they understood it. They understood it as marriage, as that wholesome gift that was given by God. We hear about the story in the Canaan, and so when there was the turning of the wine, water into wine, and so they saw it in that concept, and they dealt with it as effectively as they could. But nowadays, as long as the fallout comes, we go. I want to say, sir, that I am really very happy to learn of this, and I pray that as we go forward with the necessary counseling, with the mediation and the amelioration of some of the challenges, and paying attention to broken families and broken lives, particularly our hurting children who are part of the family, that we need to come together as a people and help to lift the burden off the shoulders of those individuals. And rather than spur on the man to say divorce her because of what, or to spur on the woman to say divorce him because of what, see how we can sit with them and talk with them around a table and meet with them and take them out and let them confess, you have done wrong, but apologize. Barbadians hate to apologize even when they step on your foot. No, Mr. Speaker. We have lost so much of our culture over the last 25, 30 years that I am beginning to not understand where we are going with this. Unless we have the passion and in our hearts and love humankind in the way that we walk about and we espouse love thy neighbor as thyself, I cannot see us getting back to where we should be, or where we could help others to make a difference. And so I support the Honorable Attorney General's representation in relation to this family law bill, the merging of these family law bills, to be able to make the adjustment so that people now who would be caught in it over that period of time would be able to feel better now, to know clearly, I have divorced that man, I have divorced that woman. We can still talk, we can still visit, we can still worship, but you have your freedom that you can marry again if you so desire, or you can remain single like as I am and I shall forever, because at the end of the day, I know me and I know what I'm capable of doing. And rather than having to go to court, Mr. Speaker, sir, with a separation as a divorce, perhaps I may have to go for something even bigger and worse than that. So I know me, and therefore I will temper myself as best as I can. But I commend any individuals out there or groups who choose to want to get married, to get married, and those who are married as far as possible, throw the differences behind them and see how best they can come together, sit, talk, get the counseling, and hold the marriage together, because at the end of the day, the youth and the young children are the ones who hurt the most, and it causes them to carry the baggage for an entire lifetime. With those comments, sir, I will wish to lend my support to this bill.
Honourable Member for St. Michael South East.
Thank you, Mr. Speaker. I beg to move that the sitting be suspended until 2 p.m. 2 p.m.
The question is that this honourable chamber be suspended until 2 p.m. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honourable chamber stands suspended until 2 p.m.